So this is a great privilege of us to have Anup Surendranath here with us to talk to us about death penalty and in the Indian Constitution. So Anup, as I said to the earlier class, was actually a student here. What year?
2007-8. Yeah.
2007. He was on the BCL, and those were the days when we were just starting out on our BCL course on socioeconomic rights, comparative socioeconomic rights. And after that, he stayed on and did a doctorate, and his doctorate was on actually something totally different, affirmative action. But when he went back to India, he started on this extraordinarily important work on death penalty, on death row prisoners, a very courageous, very difficult work, which he has unflinchingly persisted in and made a huge impact. So this is wonderful to have you back.
Thank you.
Wonderful for all of you who are studying death penalty in the comparative human rights course, and everyone else who's here. We're very happy to welcome everyone on behalf of the Oxford Human Rights Hub. This is our term, the guest lecture. So Anup has said he'll talk for about 30 to 35 minutes, and then we'll have lots and lots of time for questions, and there are sandwiches and tea and coffee, so you can get up and get things if you need them.
Yeah.
Okay, over to you, Anup.
Yeah. Thank you, Sandy, for having me, and it's always great to be back. Albeit a little strange to be on the other side. Thank you, Natasha, for putting it together. And so I've sort of framed the question. I've tried to be provocative about, and what I want to explore with all of you today is whether efforts to reform the administration of the death penalty ultimately, whether does it impede abolition per se, or does it aid abolition, and what are some of the tricky questions we have to traverse through as we explore that question. So what I'll sort of try to do today is give a sense of what, and I'm going to speak primarily from the Indian context, and I'll try and give you a sense of what needs reform in the death penalty, and then try and get you to think about how much of those need for reform is, the underlying question is whether the death penalty is a special form of punishment or not, right? And how much of it turns on that question of whether the death penalty is a special form of punishment, and what makes it special, if at all, as compared to life imprisonment or term imprisonment. And I think there isn't sufficient clarity on that question. And then I look at the compulsion of reform and why we might feel compelled to go down this path of reform, even if it might be tempting to not go down the reform path in the interest of abolition, and I'll get to that. And I'll particularly then discuss a specific example of reform that we are seeing in India currently, and the questions it raises in the discussion that I'll have before that, right? So yeah, just quickly to give context of our work, we're based out of a public law school in India, and it's staffed by permanent, it's full-time employees, and two of my former colleagues are here, and it's full-blown criminal defense. In that sense, we provide pro bono legal representation to death row prisoners in the Supreme Court, and we handle about 70% of all death row appeals in the Indian Supreme Court. We are in some high courts, but in every case, we are very clear that we challenge the conviction, right? We challenge that the evidence is not good enough to uphold a conviction, and we also then argue sentence. So it's not a sentence-based practice. It's not just strategic litigation. It's actually case after case, doing full-blown criminal defense, and through that, trying to bring in questions that are relevant to questions of fair trial, due process, and the death penalty. Just to give a sense of a large proportion of our cases are child rape and murder cases, and that's a majority of our cases. And increasingly over the years, those are the cases and there's a particular conversation maybe for another day on the intersection of sexual violence and death penalty in South Asia, but I won't be getting into that today. In terms of outcomes, we've been involved in cases where, in 2 cases where 5 prisoners were executed. We've been involved in that. Obviously, we lost that. We have won 11 acquittals in the Supreme Court in the last 7 years. The Supreme Court has acquitted 11 death row prisoners after 2 courts have upheld their guilt and the death sentence. And we've achieved about 40 commutations where the death sentence has been reduced to term imprisonment or life imprisonment, right? So that's where broadly we come from. Just quickly to get into what about, and I'll just quickly run through what about the death penalty needs reform. And I'm not going to get into each of these grounds in too much detail. One is the discrimination question, right? That who gets the death penalty. And on the discrimination question, we've generated empirical data to show that people on death row in India, like in any other retention jurisdictions, are extremely poor, belong to the marginalized sections. And as you go through the pyramid of the death penalty, the intensity of that discrimination increases, come from the trial court to the high court, to the Supreme Court, to the mercy jurisdiction. That intensity of that discrimination increases. So there is a discrimination question to ask at that systemic level of the death penalty as to who gets the death penalty. And I think there's a separate level of discrimination question to ask in terms of how does discrimination play out in individual cases. And I think those are 2 very different issues to consider. And what matters, when would you say that in an individual, how do you make this transition from the systemic argument of discrimination of the death penalty to a case of individual discrimination in a particular case? And I think there are tensions there to work out, and I don't think it's as simplistic as saying that the client that I'm representing today belongs to this group that I have systemically shown to suffer the burden of the death penalty, right? I don't think it can be just a simple argument like that. And I think demonstration of discrimination in individual cases necessarily would mean more than just showing membership in a group. So that's on the issue of discrimination. Second, on another issue that needs reform, and I understand that when I even start this conversation in the framework of reform, I'm accepting that we are operating under that the death penalty is in operation, that it's valid, and we're now seeing what aspects of the death penalty can be reformed in that sense or changed. The next issue is of the treatment of death row prisoners. Our prisons, depending on which state you're talking about, the treatment is quite distinct from other prison population, other convict populations, in terms of access to education, access to work, access to facilities. The system always seems to operate under this perverse logic that since anyway these people are going to be executed, there is no real reason to give them access to work or education or any of the other facilities. And again, it's not our prisons are a state subject and therefore regulated differently in different states. But the treatment of death row population as distinct from general prison population is an important issue. And I think there is very close connection to the experience of being on death row, right? And I think that is another big area that is often understudied, I think. What is the experience of being on death row, right? Is death penalty torture? And I think there are interesting positions on that in international human rights law, where it's not gone as far to say that death penalty is torture, but what is it about the experience of the death penalty that might raise conversations that it amounts to torture, right? And I would urge you to think about the fact that it is not particularly connected to the moment of execution. It is not connected to that death or pain of execution, right? And then I think there's much more connection to the experience of fearing one's own death constantly or anticipating one's own death and having to live through that on a daily basis. So, and I think that's one part. And I think our more recent work by my colleague Maitreyi Mishra, who we did an extensive study on the mental health of death row prisoners, and what consequences on mental health does it have to live on death row, is a complicated interdisciplinary area to traverse in terms of saying what methodologies would you use that is acceptable to psychology, psychiatry, and how would you understand the mental health implications of living under such a punishment. And it raises questions of, is the state inflicting more suffering than it can or it should by exposing prisoners to this vulnerability repeatedly? And yeah, that's in a publication called Death Worthy, and I think it's quite an interesting assessment of how mental health operates amongst the death row population. Another area that requires reform is obviously access to legal representation. By virtue of their poverty and their marginalization, the standard of legal representation is quite abysmal. Then there's a well-documented issue of arbitrariness in which cases end up getting the death penalty and which cases don't. What does arbitrariness mean in sentencing jurisdictions, right? In the sentencing jurisdiction, what would you count as arbitrariness? Is it that, I mean, it can't be that we can't understand arbitrariness as all rape and murder cases of children below a certain age should get the death penalty, right? Very often it gets confused with that. I mean, I think sometimes arguing in court, it is convenient to argue it like that, saying that here are 10 cases where it meets the profile of our current case where death sentence was not given. So please don't give death in this case either. It's convenient to argue it as a matter of court strategy to show that table to judges, and judges you sort of hope that you stump the judges with that, saying same profile of victims, similar circumstances. Here are a list of 15, 20 cases where death was not given. But I think in understanding arbitrariness, it's of a deeper problem of how to use precedent. How should you use precedent and findings of fact in a sentencing procedure, right? And there's that deeper assessment to make on understanding arbitrariness and the use of precedent. An issue that's particularly not spoken about is the secondary victims of the death penalty in terms of the families and the children of prisoners. What is the impact it has on them, right? And how do they experience what you might think of as the suffering of death row, right? And is that, and you might raise the question immediately, is that any different from secondary victims of imprisonment and long-term incarceration? And how would you view this? And I think that's a good, and yes, should death sentence cases be subject to special legal procedures so that they get more attention, they get more scrutiny? Should there be additional checks and balances in death penalty cases as compared to other criminal appeals or other criminal cases? So all of this, I think, leads me to the next question on, is the death penalty a special punishment, right? Is it different from term imprisonment or life imprisonment? And what makes it special, right? And I think we might consider that question from certain aspects, and I'm not offering a response here. One, I think immediate intuitive response is that, okay, we need to treat the death penalty in a special manner because it is irreversible, right? That its irreversibility is of a very different, I mean, that concern is of a very different moral order, that we could get it wrong, and therefore we need to try and get it as right as possible. And that's one concern. And there's a certain normative limitation to that in terms of saying that then our concern is only when we get it wrong, in that sense. It almost tends to attach itself too much to questions of innocence, right? And there's a deeper philosophical problem there of attaching the concerns of death penalty to questions of innocence, as opposed to a much broader concern of the nature of punishment itself. And that leads me to the specialness might be in terms of that taking life as a punishment is different, right? That the nature of the power that the state is exercising. So it's not really about its irreversibility, but the extent of the state's power being exercised here and the extent of deprivation of rights. That is the problem. It's not irreversibility that's the problem. That is the extent of state power and the extent of deprivation of individual rights that requires us to treat this punishment differently from term imprisonment. And that's qualitatively different, one could argue, from term imprisonment or life imprisonment, right? And I think thirdly, the special, and I think this literature is only emerging on this, is that the suffering of the death penalty, that your experience on death row, what you might call the death row phenomenon, is qualitatively different from experience of imprisonment, right? Questions of, is that dependent on each individual? Is that dependent on each individual's biopsychosocial factors? So it's not really anything to do per se with the punishment. And you could have, is it a consequence-related argument that one might have to show that each individual, it need not be true that the impact of the death penalty on all individuals is the same. So broadly, the question of the specialness, at least the way I'm thinking about it, the specialness of the punishment either could be attached to its irreversibility or the nature of state power or the extent of infringement of individual rights or the suffering of the death penalty, right? So it could, I mean, I think it's in that universe where the special nature of the death penalty operates, right? It's there and thereabouts, I would think. So if there are all these areas that I spoke about that require reform, and they require reform because we consider the death penalty to be special, that death penalty is of particular concern, then the question is, what is the compulsion of reform, right? And to think about sitting at the intersection of that we do research and we also do litigation, what is the compulsion of reform? I would think that you can view it in a couple of ways. One is that the more you reform, the more you will restrict the death penalty, right? It is sort of trying to slowly kill the death penalty, right? That you make it harder and harder. You have more and more procedural requirements. There are more procedural tests. There are more special procedures for the death penalty cases. That, so what you're saying that, okay, might not be that either representative bodies, as parliament or whatever, or courts are not willing to strike it down, right? Are not willing to do away with the death penalty per se. Then reforms are viewed as a way to slowly cut the supply of death penalty cases, right? That you're providing, in that sense, lesser and lesser bodies to be executed, right? That you're reducing the supply that is finally reaching the stage where clemency petitions are denied and then people are sent for execution. So that's one way to view the reform question, right? That we need to reform the death penalty because the complete abolition is too much of a challenge politically or judicially or in terms of a constitution, and therefore you're narrowing the supply, right? The second is to say that this is not really about that thinking of reforms is not about strategic ends. It's not about strategic goals. It shouldn't be so instrumental, that it is really about individual rights, right? It is about the rights of individual prisoners and what fairness demands of us, what fair trial rights and due process demands of us, that it is about that this shouldn't be tied to questions of strategic instrumentality, if I may call it that, right? That we shouldn't view these questions of what we should reform and how much we should reform, that if we can better the fair trial protections for one individual, then that's all that really matters, right? And we should then attempt to bring in various reforms on these grounds, right? Now, one, and I just want to spend some time discussing one of the reforms that we've been quite involved with in the last year, and has been a few years in the making, really. And it really took a lot of effort over some years where courts and lawyers were completely unresponsive. And then, and there is a certain merit in terms of just litigating the issue of being before the court in as many cases as possible, right? And it is not, and as opposed to a strategy where you might say, I might pick that one case where I might raise the strategic issue. What we have chosen to do is not that. We try and ensure that we are before the Supreme Court in as many individual criminal appeals as possible, so that we are raising these issues and concerns repeatedly before the court, right? And ours is a court where, the bench you get today might be very different from the bench you get tomorrow, 1 year down the line, because there are our Supreme Court doesn't sit en banc, right? They sit in benches of 3. So a lot depends on who the judge is. But there's great merit in thinking about, or important to think about, what is the value in ensuring that you are pushing the judges to think deeply in every single case, right? To try and ensure that very few cases go without getting the kind of attention that they deserve, right? And there is value in that. It is, of course, demanding, resource intensive, and it comes with certain costs, and both human and financial. But there's that. But what I want to say is that what we tried in each of these cases is to say that, and I'm just on the sentencing part. I'm not on the that the prosecution has not met its burden of proof, and there's a lot to be said about what is the quality of evidence in these cases, right? And what has been found to be sufficient evidence to convict and sentence these people to death is a completely different conversation, and really requires attention to say, it's just shocking how poor the quality of evidence is. And that also reflects how poor the quality of legal representation was, that this kind of evidence that we're talking about was good enough to not only just find a conviction, but also then to sentence that person to death. But the reform I'm talking about is not on concerning any of that. It's on sentencing and what we call, and I assume you've already done the death penalty module. What our framework is, a rarest of rare framework, right? In Bachchan Singh, where the death penalty was upheld. And one requirement under that was that the court has to consider not just circumstances of the crime, it also has to consider circumstances of the accused, right? That it's not just, you can't just say the crime is brutal, it is terrible, and therefore the death penalty must be given. It has shocked our conscience, the society's cry for justice. You can't just focus on the crime, and that's the law, right? That it also required collection of mitigation circumstances. Now, unfortunately, for nearly 42 years, very little attention was paid during the course of this time as to who is going to collect this information, right? That if you're saying that for fair sentencing, right, for a fair sentencing process, mitigating circumstances about an individual's life must be presented to a sentencing judge. And our sentencing is by a judge, it is not by a jury, right? Who is going to collect it, right? And you have to map this against the reality that most of the death row prisoners are extremely poor, right? And therefore, we started in our cases for a long time with absolutely no response from the senior lawyers. We were getting to argue our cases, what you might understand as QCs or KCs now, what we call them senior advocates, right? So even getting them to engage with this has been a process, would appear for us to say that we need to collect these mitigating circumstances. Who is going to collect it, right? And what does collecting mitigating circumstances mean? And a fundamental challenge that we struggle to answer, and I'm going to throw it at you as well. If I were to ask you, why should the childhood experience of somebody who's been convicted of child rape and murder matter? Right? Why should their childhood circumstance matter? Why should we investigate the life history of our client into sometimes even as far as how their mothers were during their pregnancy, and what whether there was alcohol abuse or substance abuse when they were a fetus, right? Why should we do it, right? Why should it matter? And that's a question we get from courts and lawyers. How does it matter whether I'm poor in deciding my sentence of whether I should be hanged to death for child rape and murder? Why should it matter whether I am poor? And I think there needs to be a very clear normative articulation of it, right? And the answer to that is rarely ever legal, right? It is, and I think lawyers, judges are bad with interdisciplinary stuff, right? Sorry to, right? I think they are intimidated by it. It's part intimidation and part scorn, right? That no other discipline really has anything to offer to processes relevant to the law, right? And the truth of that matter is, and therefore you get into questions of, oh, not all poor people rape and murder children. Right? That is a question, right? If the moment you say this, oh, this person is poor, the issue is, oh, how does that matter? Are you saying that all poor people commit heinous offenses, right? And they have to, that fast food question does not have a fast food answer, right? That 15-second, oh, that's such a sharp, smart question, seemingly on the face of it, does not have an equally snappy answer to it, right? And it involves necessarily introduction of interdisciplinary ways of thinking about how human beings develop, how their personality develops, how their mind develops, how their behavior develops. And those are very detailed, complicated investigations that lawyers are completely incompetent to undertake, right? Our training as lawyers just doesn't teach us to do that, right? We are taught to go for what, I mean, relevance is such a crucial term in the practice of criminal law, right? That lawyers just don't want to spend time, spend those hundreds of hours developing the confidence in your client, that the client and their families can reveal the darkest part of their lives to you, right? And to get through to your client that what you want to hear are the worst parts of their life and not the best parts of their life, is perhaps the most complicated task, right? Gaining that trust that you will not abandon them, right? That irrespective of how bad their life was or how bad many things that they have done themselves, that you will not abandon them. Reaching that stage is a very complicated journey, right? And what you will know about your client in, let's say, 6 months versus what you will know if you've been investigating their life for 4 years is very different, right? Sometimes listing of matters happens such that we only have a week to find out things about our clients. Some cases we've been investigating for 4 years, and you can see the difference in the depth of how much we know about their lives. But it fundamentally still requires you to answer the question in court: why does any of this matter? Should it matter? And lawyers and judges should be able to answer that question. And our jurisprudence, unfortunately, has not had it has stated the position that there must be mitigating circumstances, but there hasn't been any real in-depth engagement on why should it matter. And as a result of that lack of any real normative basis for why it should matter, right? We get really shallow judgments on both cases that commute the death sentence and also that confirm the death sentence, right? And so a part of this has been to, the reform that I'm talking about is to constantly bring in this kind of mitigation information in cases repeatedly, even where they were ignored, ridiculed, whatever, the lawyers didn't care or the judges didn't care, to keep doing it repeatedly, and to start getting people who are specialists, either as social workers or sociologists or mental health experts, onto your team in terms of to investigate the lives of your clients and present it, to get courts to accept that, yes, these might be things that non-lawyers have written, right? These reports that are being written are by non-lawyers, but by psychologists or psychiatrists or whatever, right? And you need to look at them, right? And I'm not saying now they have suddenly transformed and they understand why it's relevant or whatever, but at least it is a step forward to say introduction of these perspectives, these materials, even these documents is a significant step, right? So in achieving that, right, there is now conversation on should all capital cases have mitigation investigators, right? And the court's concern on that, and it's been great to be part of that process where the court has recognized why this is important. And this is something the law has not addressed, and we need to address it. At what stage do we bring in the mitigation investigator? Is it at the trial? Even if it's at the trial, at what stage of the trial? Are we going to have resources to do this across India, right? Should the Supreme Court lay down a guideline that no court in India can undertake sentencing process without the report of a mitigation investigator or a mental health expert, right? Should that be the law? Can the system deliver that, right? Can the legal aid system deliver that? Should we now look at this as that just like we provide legal aid lawyers in these cases, we should also provide mitigation investigators? How much of this should be a question of practicality? And that's a question I want us to think about today. In suggesting this reform, if you were strategically thinking about this, how concerned or how would you address the question of practicality? Should, as a lawyer, in an attempt to reform the death penalty, should you suggest, or how much should you factor in concerns of practicality? Or is it in your interest to say that practicality should not be a concern, that it is just about what are the rights entitlements of under the due process framework and the fair trial process? That is what we must have, because the punishment is so special that I don't need to worry about, or court should not worry about, can the legal system actually provide for a mitigation investigator? And it is only the job of the court to say that, yes, a fair trial requirement is that every prisoner, a death row prisoner, potential death row prisoner, get a mitigation investigator. And these are questions that cannot be decided by practicality. And that the strategic value of not having practicality in these cases is to say that inevitably this is what will lead you to show that reform is not possible. That in case after case, you want to show that you said, yes, fairness requires, or the rights entitlement was that you have a mitigation investigator, that either a mitigation investigator was not appointed, right? Or even if a mitigation investigator was appointed, that the reports being filed are so terrible that it is in your interest in that sense to have an impractical solution, to have an impractical reform, to show that, yes, that is the gold standard and we're unable to meet that standard, and to show that, but that also assumes that that the system is capable of pointing out that failure in case after case after case after case, right? And everybody knows that the system is not capable of delivering this reform, right? And so at this stage of crafting the reform, the main concern with the court, and it has referred this to what we call a constitution bench, which is a larger bench of 5 judges, the dominant worry is practicality, right? And that's a very interesting thought. Why should a constitutional court be concerned about practicality of resources, of availability of people when deciding such a rights question? In deciding such a rights question, and when I say such a rights question, I attach it to the special nature of the death penalty. And again, that of course then assumes we agree that the death penalty is special, right? So it's fascinating for me that how questions of practicality in something like this, given the rights invoked, get attached to questions of resources and resource allocation. And I'm sure that's a theme that you have repeatedly revisited in multiple modules across the course. Right. So, and the danger of the reform strategy of something like this is that it is completely dependent on what you do after you achieve the reform. That you have to show that the reform does not work. Because you don't want the system to assume that it has done its job and reformed the death penalty. It has made the death penalty fairer, right? Because that's what the system is now thinking, right? That, okay, there are problems. We concede there is, yes, the value in this is there is an acknowledgement that there is a certain crisis in the administration of the death penalty. And there is now an effort to say, let's fix it. But from the other side, as lawyers litigating against the death penalty, that strategy assumes that you can repeatedly show that the reform does not work. Because if you don't have the capacity to show the failure of that reform, you're really leaving yourself in a tough place where you have legitimized the death penalty even more, right? You have said, yes, we made it fairer and, you know, it's all good. Everything's working as it should, right? So in that sense, the challenge of a reform-based strategy towards abolition is always to show that the reform is not working, right? Right? And yes, the assumption is that the reform will not work, right? And these reforms cannot work because there are some fundamental endemic flaws to the criminal justice system that cannot be fixed, right? At least cannot be fixed like this. So when lawyers like us take up reforms, it needs to also come with the recognition that there is a subsequent burden that you haven't won the battle with that. Your battle is very much the next step to document, to collect evidence, and then show over time that the reform is not working, right? Because if you do not do that, you've basically shot yourself in the foot, and you have made the system feel a lot better about itself that it has reformed the death penalty, right? And the idea is to show that something like the death penalty cannot be reformed, right? As what Blackman called that you can, whatever, that he said that he shall no longer tinker with the machinery of death, right? So yes, so I think that's the challenge and that's the opportunity. There is an opportunity, I think, to in systems where we feel that either there isn't the judicial will or the political will to do away with the death penalty entirely. The strategy has to be to squeeze the death penalty more and more and more and narrow that pipeline, right? But for that to work, it's not just about strategic litigation. It's not just about winning the reform. It is also about necessarily having to show, as I said, that the reform will not work, right? I'll just stop there. Thank you.